Welcome to another episode of the Property Nomads podcast. Today we're going to be deep diving into tenant evictions. Obviously, with everything that's going on in society at the moment, this aspect of property has become a little bit more challenging. But in order to help answer some great questions, we're delighted to be joined by Alex Cook, who is the director of Helix Law. And over the last 13 years, Alex has specialised in commercial and complex property litigation, acting for investors and landlords across the UK and internationally. Alex has been instructed in or supervised hundreds of landlord and tenant disputes. He's remained active throughout the COVID crisis, providing legal advice and resolving issues for landlords and investors involved in such disputes. Alex has also contributed to so many great articles recently, including things for Bloomberg, working on something with the Sunday Times as well. We'll put links to that in the show notes. Alex, thank you very much for your time today.
No problem. No, good to join you, Rob. Thanks for having me.
So tenant and eviction processes, they can be quite complicated at the best of times. But I guess before we touch on that, just giving a bit more about your background, but what got you into this area of work in the first place?
Oh, good question. So I think, to be honest with you, I always enjoyed the public speaking or debating. I kind of naturally played devil's advocate. And so I always looked for I want to say the argument, but, the other point and the other perspective. And so I actually started out, I sort of academically trained as a barrister at the outset many years ago now. I was very attracted to the bar. Unfortunately, my mum died, long story short. And so I basically ran a couple of businesses whilst studying, and it gave me a flavour for kind of I want to say almost entrepreneurship, but business, small business of a certain size, working with people, working with clients, and that the barrister world, it's very sort of pick up the brief. You're the face of the dispute, but you don't really get to move any of the chess pieces. You don't get to have the sort of conversations with the clients on how to sort of move things forward to try and resolve their dispute, which is particularly relevant on more complex commercial matters, but perhaps less so with the landlord and tenant stuff. But you're still dealing with interesting people, and all of that. It sort of made me think, do you know what? Actually, I'm much happier being a specialist litigation solicitor rather than a barrister, and that sort of led me down this sort of path for my sins.
No comment on that. It's always good to get some. It's always good to get some background, and I can, and I'm sure as people will attest to, the world is changing every single day, and there's been a lot of challenges with systems and processes involving tenant disputes, whether that's regular residential or commercial. So, to give people a brief understanding. Before all of this happened, and we're talking COVID, before all of this happened, if you wanted to remove a tenant from a property, what would that process have looked like in regular times?
Okay, so good question. And I guess the process at a high level hasn't really changed. Okay, the detail has changed, but in simple terms, you're a landlord, you have a tenant, you've got a problem, let's say. Maybe you don't have a problem, maybe you just want to sell the property. But in any event, you have to serve a notice. That's the first step. If the tenant remains when that notice expires, then you have to issue a claim, you have to obtain a court order, and then you have to enforce that court order, usually via bailiffs. The other option, of course, is that you can reach an agreement with a tenant. And I think, again, this is often overlooked. There's this fear of sort of having to evict, etc. But, I can tell you now, it's something like 1% of rentals end up requiring a claim, for example. So it's an incredible, 99% of landlord and tenant relationships are absolutely fine, but it's the 1% that you're pulling the pin out the grenade, and it becomes a much bigger issue and leaves a kind of wake of destruction. But long story short, you serve notice, you get a court judgment, and you then enforce it via bailiffs. And that was the position previously. What has changed, or at least a big change, at the notice periods, and subsequently leading into COVID, we've had an awful lot of legislation basically that has been issued kind of on the fly, frankly. It's almost an afterthought. There are bigger things going on. I think we all know that, particularly March, April time. And government really, rightly or wrongly, I don't judge, that's not my role, but it's sort of, people don't want to be dealing with housing and court disputes over evictions. And so an awful lot of legislation came through the system, including obviously a stay on evictions, which means a pause on a landlord's ability to evict. And what we're now facing is kind of the impact of that, but perhaps we're going to lead into that, I suspect. But yeah, the notice period is really the big change in the process, at least in the short term. Some longer term impacts likely to follow, which again we can talk about more. But yeah, that's the current position that we're in relation to notices having changed especially.
Okay, so as you said, we'll touch on sort of every single point you just said there, because again, it's the whole sort of purpose of having the episode anyway.
Huge topic. Sorry, Rob. Yeah.
Absolutely. I mean, we could probably go on for hours about this, so we'll try and limit it to the 30 to 40 minutes there. In terms of notice period timeframes, and say you mentioned a lot of, the Coronavirus Act 2020, amongst other bits and pieces coming out there as well. So what would the normal notice period have looked like in comparison to what it is now? What are you seeing?
Okay, so notice periods pre-corona, meaning in my world pre-March, March 2020, you're looking at 2 months for a Section 21, as it was then, or 2 weeks for a Section 8. And long story short, I suspect a lot of people will appreciate the difference already, but a Section 8 notice is used where there is some degree of tenant fault. So tenants not paying the rent, or they're not looking after the property or something. So you'd use a fault-based notice, Section 8 notice. And that was 14 days pre-March 2020, whereas a Section 21, 2 months. And that's a vanilla, I'm the landlord, you're the tenant, I'd like back the property, please. That would be a 2-month notice that would be served. So that's the position kind of pre-March.
And the effect that we're seeing nowadays, and again, I actually came off a recording this morning, sort of going off on one about the fact that we got, because it's virus related and the virus is spread if people are meeting people. So I understand why, as you said, appreciate that this isn't exactly number one on, the government's list. In fact, it's still Brexit as well. But anyway, let's not about doom and gloom. What changes have been made then to the timeframes, and how has that impacted the work that you have come across since March?
Well, I mean, good questions. So let's just deal with the first of those. So notice periods, okay. Both for a Section 21 and a Section 8 notice, the notice periods are now 6 months as a starting point. So forget your 2 months, forget your 2 weeks, you're now into 6 months as a starting point. I'm focused here on England, just as an FYI. There's obviously different legislation that applies to Scotland and Wales, but let's just focus on England. And so, a vastly longer period of time now is required for landlords. You've got a problem, say, with a tenant, you're now serving a notice and you're having to sit on that for 6 months, which is extraordinary. There are some exceptions. And just in terms of rent arrears in particular, you're looking now at if a tenant has more than 6 months worth of arrears, which seems like it's a crazy amount of time to be carrying. But as a landlord, if the tenant is in 6 months arrears, then you can serve notice as a Section 8 notice, and that still has a month notice period, but it's a damn sight shorter than 6 months. So that's the current position as we sit here now, as painful as that is. Turning to the second of your question, just in terms of the impact on our work, well, I think for most landlords, I should say really for most investors in property are landlords, okay? That's an inevitable sort of consequence, unless you're, say, developing out and selling and what have you, but focusing on the landlords, investors. The big impact has been that there's been a stay on evictions, and that stay only expired in September. And what I mean by that is you've not been able to issue a claim. So as simple as that, really. The courts weren't accepting claims. And the reason for that was just from a public policy perspective. We're all in a lockdown. They didn't want the local authorities having to try and find housing for people in the lockdown period, etc. So, all of that has been a consequence. And so as a result, it's just literally we're going to hit the pause button on all evictions. I would say, again, speaking kind of on behalf of landlords and on behalf of investors, you're at risk of kicking the can down the road there. That creates other problems. Landlords have not received significant government support, for example, and although there's been much talk of mortgage holidays, there's nothing really new in that. That entitlement already existed. And it doesn't do you much good if you're a landlord, you've got mortgage payments, you're now possibly at risk of arrears because you've not been receiving rent for 6 months, etc., between March and September. So, there's sort of a lot of consequences of that. We see this, in our work. Again, for very obvious reasons, there are no claims. There's been a reduced number of claims, unsurprisingly. Between March and September, it's just not been possible. But there's been an awful lot of talk about the impact of the end of the ban on evictions. And that ban has expired. It expired in September. It's too early to meaningfully talk about volume of claims, but there's been, a lot of assessment or analysis on how many backed up claims, if you like, there are in the system waiting to be issued. Landlords, investors sat on problem properties, as it were, difficult tenants who aren't adhering to the ASTs, and the need to issue those claims. Claim volumes naturally are not, they're not sort of huge in comparison to the overall rental market. They're sort of, you're looking at tens of thousands, yes, a year, but in comparison to the millions of tenancies, it's a low percentage, as I've said, that need a claim. But in the last 6 months, you've had not only that natural kind of backlog add up, it's kind of creating a curve, but a backlog of claims. But you've also had potentially a greater number of claims naturally as the impact of coronavirus on jobs and people's ability to pay rent, etc., kicks in. So, it is too early to say, but there's been an awful lot of talk of tens of thousands of claims being waiting basically to be issued. And I think there's some truth in that. We see it in terms of court turnarounds and the time that it's now taking to evict, which is going to be longer, frankly. But I hope that kind of answers the question. We had a process pre-corona, and unsurprisingly, the world has changed. And now I think there's basically a newish process. As I say, still notice required, still claim required, but it's basically going to take longer. That's the high-level conclusion.
It sounds quite similar. Sounds like there's a lot of, I'm just going to say pent-up demand. That might not be the most technical phrase going, because it's the same with the changes that, say, the government made with regards to stamp duty. Admittedly, there has been other things regarding permitted development and changes to, planning legislation. Yeah. Anyway, It's similar to what you've said. It's this 6 months, effectively, of this pent-up demand. And from a stamp duty and buying point of view, they've sort of said, take this until the end of March 2021, and most people have just gone, they're straight out there, they're buying. There's been, I see a few things here and there, people bidding wars, doing this, doing that, because all that demand has just, flooded out and gone, burst. So would you say that's a fair correlation to what you've just explained with regards to all these claims? Is just a deluge of things, basically?
Yeah, I mean, I don't mean to kind of over-egg it, and the truth is, at the moment, there's a high degree to which we don't know. We don't have the stats from the Ministry of Justice. We're a month in. We won't have those until January. But at the same time, I can look at the statistics on the number of claims that are being issued just naturally. It's a percentage game. It's a numbers game. And you can see that actually consistently every year, I think it's in the region of 100,000 claims, possession claims are being issued consistently year after year. It doesn't really fluctuate hugely. Well, if you turn that tap off for 6 months, what do we think is going to happen to those 50-odd thousand claims? Because I sit here and I think, well, they're not going anywhere. They're still there. They're still floating around. And then we say to ourselves, okay, well, there's a likelihood then that when we turn the tap back on, end September, October, those claims are going to need to be issued. Those are landlords, investors who are sat on problem properties where they need to regain possession. Those are likely to be added. That's immediately going to create a bottleneck in the courts, because that's just the natural run rate. And then we say to ourselves, my goodness, hang on a minute, we've got coronavirus here. What do we think that has done for claim numbers? Do we think that's decreased the number of likely claims or increased them? And I sit here and I say transparently, I think it's highly likely it's increased the need for claims amongst landlords. Perhaps tenants not paying rent, perhaps not understanding the narrative that has come from government, other sources, that is at times unclear. It's almost been impliedly suggested that it's okay, there's a ban on eviction, so don't bother paying your rent. I think at times that has been unclear. And so, question mark, are the courts currently dealing with greater number than just those backed up claims or more, and I think possibly more, frankly, just because of the circumstances that we're now facing. So the courts are dealing with that right now.
I think that one of the challenges that most people have is that, you know, this situation, we're not necessarily talking regular recession. We've got this external factor that we've, as a society, we've not dealt with for just over 100 years. You know, Spanish flu is really the last major thing on this level. So it's interesting because, you know, I think anyone can go back and study history and sort of see the most ideal ways to deal with it. But then fast forward 100 years, and, you know, all of us are flapping around with X, Y, and Z. Sometimes sometimes you cannot plan for these things. Sometimes they will happen, but a virus is a virus; it will spread anyway. So it's interesting that all of this stuff's pent up, and, you know, economically speaking, it's dangerous because it's just going to create, as I was saying this morning, that, you know, what a government reaction to a lot of things, rightly or wrongly, is they're just printing. They're printing currency. That's just our government. You know, worldwide, it's pretty much the same, and that's going to create, you know, economic catastrophe. It's possibly an economic Armageddon at some point. That sounds doom and gloom, but, you know, as you say, you've got to look at the numbers, you've got to look at the stats of it, and that's seeming, you know, that to me is the reality of it. But,
I think what's interesting to me in all of this as well is that there's been a continuing kind of narrative that I see, you know, just publicly, different organisations. I don't mean to kind of single any out, but right at the top of the list would be Shelter, unsurprisingly, and they're creating this sort of narrative of an us versus them, and I'm not sure it's fair or justified. You know, landlords are, yes, they're providing a service, and yes, they're sort of charging for that service. But landlords don't have a business without tenants. Most landlords and investors know that. They don't want to pursue claims. You know, people who arrive at my door, it's, you know, invariably, they've already been trying for months to reach out to tenants to resolve these problems, to see if there's any middle way. They do not want to have to issue a claim at all. And it's kind of, you know, really a last resort. And I don't really see that being reflected in sort of what I hear. It's kind of, you know, particularly around the number of evictions. It's almost now being pitched as though that in itself is a problem that needs to be tackled because, you know, bad landlords are evicting people throughout the global pandemic. That's kind of the narrative that I hear and I read. And you don't really get the flip side of that, which is they're only doing that because they've not been receiving rent for 6 months or even longer. I mean, I'm dealing with claims that were issued on 6-9 months in March, and then now, you know, you're well over a year of rent arrears, and those landlords have all got mortgages. You know, the vast majority of landlords in this country, they're not kind of, you know, your mass portfolio landlords. It might be they've inherited a property, they might own one or two. It's kind of that informal landlord-tenant sector, and it's just, I don't think that's helpful, to be honest with you. I think we have to just take a step back because this all feeds into policy, housing policy. And it's not good for us all to kind of see this as an us versus them type debate. It really doesn't help anyone. And this feeds into some of the legislative changes that I've seen sort of talked about in terms of banning Section 21s. You know, that is bad for tenants, let alone bad for landlords. You know, it really is. Again, a separate point.
Well, let's actually go on to that because, again, as you say, communication is important anyway, and having that us versus them mentality, I think, you know, I've been sort of involved on and off in property 4.5, 5 years. So in comparison to other people, you know, some people have been doing this for decades and decades. But it seems to me that seems to be the underlying thing that in years gone by and where we are now recording this, it does seem to be an us versus them mentality. But dipping into Section 21, as you just raised a great point, I mean, that created a hell of a lot of uproar when that was first mooted. So from your opinion, what would the consequences be if they were banned?
Okay, so I think let's just take a starting point here. Section 21 notice is a no-fault notice, as I've said. So I'm a landlord, you're a tenant. I'd simply like my property back. I serve you a Section 21 notice. That then enables me at the moment to use an accelerated possession claim route. Okay, so as a starting point, I issue my claim, but there's no court hearing. A judge would look at that on paper, and as long as my notice is valid, I'm going to get a court order, and ultimately I'm going to regain possession, which you'd kind of expect. You know, that's the tenant has ignored the notice, it's valid, landlord should recover the possession of the property. The reason that is important, I think, as a starting point to understand, is that a lot of landlords use the no-fault eviction route of a Section 21, even where there is fault by the tenant. So in other words, you might be a landlord and have a tenant who's not paid rent for months, but I might still advise you to use a no-fault eviction via Section 21. And why would I do that? Well, it allows you as landlord access to the quicker, cheaper, more efficient process of the accelerated possession claim versus pursuing a Section 8 claim that a tenant can defend, can counterclaim. It takes longer, it incurs money, etc., and costs. And the upside for you is actually very limited. Yes, you might get a money judgment for the arrears, if there are any arrears, but against a tenant who might not have any assets or even a job or means to pay, that might just end up being a piece of paper with a stamp on it. So, again, if we cut to the chase on that, Section 21 notices are used a lot by landlords, even where there is fault. So that's why it's a bad thing for landlords for Section 21s to be banned, because it's going to basically mean they lose the route to the accelerated process. But it's actually also bad for tenants, and I never hear this really spoken about publicly, which is really odd to me, because it's a really bad thing for tenants. And the reason why is this: if we accept as a starting point that landlords use Section 21 notices even where there is some degree of fault by the tenant, the reality is that if they lose that, they will have to still pursue a claim against the tenant via the fault-based notice, the Section 8. These claims are not going to go away. My tenant's not paying the rent. I'm going to have to issue a claim at some point. I've got mortgage arrears or whatever it might be. I've got to resolve this. So those claims are still going to be pursued. So it won't save court time in that way, but it's bad for a tenant because of the onus and the obligation on local authorities to rehouse tenants. And what do I mean by this? Well, if I'm a landlord and I pursue and I succeed in obtaining an order against a tenant on a Section 21 notice, that tenant is considered to have been made involuntary homeless. And that's a technical meaning. It means that the local authority has an obligation to rehouse that tenant. So the tenant will not be made homeless. They will be rehoused where I, as a landlord, use a Section 21 notice. That is not the position with a Section 8 notice. If I, as a landlord, pursue a claim against a tenant using a Section 8 notice, and I win, I succeed, the reality is that tenant will be considered by the local authority to have made themselves voluntary homeless by not paying the rent. And so they will not have an obligation then to rehouse them. And the tenant will either have to go off and find another private landlord, might be difficult with a judgment against them, or they are going to be homeless. And so if you think about housing policy, the whole point of, as far as I can see in the media, etc., the argument being made for banning Section 21s is that landlords need to be kind of brought under control. There's too many evictions, bad for tenants, they need longer, etc. All of these sorts of arguments. But the reality is you're at risk of increasing homelessness by taking this approach. And that just, it can't be good for tenants, just as it's not good for landlords. So that's before we even get into you're turning off inward investment into social housing from private landlords. You're obviously doing that, but just on the detail, it seems to me to be disjointed.
And that will come down to communication. Now, first of all, actually, an incredible point raised that, again, I don't think many people would have heard of or would understand. Again, it's all the landlords need to be X, Y, Z, but scary, isn't it?
I know it is, and it's pretty incredible because, again, unless we have, I think this is also part of the bigger debate. Okay, the role that landlords, private landlords, the PRS, private rental sector, have in housing in this country. Because I look at it and I think, well, my goodness, if you turn off private sector investors, landlords from providing housing in this country, who's going to fill that gap? Because the state, be it local authorities or central government, consistently, regardless as to which side of the political sort of barometer you're on, there's a consistent lack of investment in housing. And so at the moment, if you turn off the PRS, private sector landlords, from also investing, continuing to provide property, you're facing a real housing crisis that you're making worse because you're turning off people who have the money and who are already investing in it. It makes it less attractive. We can't evict problem tenants. What am I going to do? I've got a mortgage, etc. I've got a property sat there that's not generating any income. You've got to strike the balance here between those investors versus the rights of tenants. And I'm not sure that these policies are really thought with the long term in mind. The concern is that actually it's a really good news headline under a lot of public pressure from people like Shelter, Generation Rent, and all the others. A lot of pressure on politicians to push through these sorts of policies, but actually bad for tenants as well as bad for landlords.
Would you say that was that's I was trying to think of the best way to phrase this question. Basically, I guess a little while ago there was, I think it was Labour, were mooting around the idea of having a minimum of 3 years for a tenancy agreement, which, I mean, that created an awful lot of uproar. What was your view on that?
Yeah, I mean, I think what's pretty incredible about that is that if you were to ask most tenants if they want to be tied into a property for 3 years, I've rented previously. I don't rent now, but I've been a tenant. I would not want to tie myself down for 3 years. You're kidding me. I need the flexibility. I wanted the flexibility at that time. And so I think, again, it's a question of striking the balance here between, I've seen arguments that, tenants are incurring costs and having to move too often and what have you, and that they need longer notice periods to give them time to prepare. I'm happy to hear those arguments. I get it. Even then, I would say you're dabbling with legislation that has been around since 1988. That's the Housing Act 1988 sets the scene for this, these notices, etc. It's been around a long time, and it's worked, and it's. Again, what has changed subsequently, apart from the cynic in me thinking, well, we're going to chase the votes of tenants, and we're under more pressure from different organisations that have got organised in terms of their, again, this narrative of us versus them. That's the only change that I can see. You can deal with these things by, again, extending the notice periods. Fine, perhaps there's an argument for that. But I think, to kind of lock people down for years on end, I genuinely don't think it's what actually most people want. And there's already nothing to prevent people from agreeing longer, short periods. But, it's kind of a separate point now. But, again, landlords have to have confidence in their ability to evict problem tenants if they're going to be forced into long-term agreements like that. And, this is another point on it, which is, the reason that landlords might say go for 6 months initially, which would be my advice, incidentally, with any new tenant before you get into a long-term sort of relationship, effectively go for 6 months initially, not least because that's relevant if you need to later evict them. If you've entered into a 2-year or a longer assured period, you can't serve a Section 21 to expire before the end. So, you've got to keep all of that in mind. So there's an active disincentive in that way. So on the one hand, you've got the tenant stuff, and on the other hand, you've got the landlord reasons as to why it's a bad idea. But I just think there's an awful lot feels as though it's on the fly, some of this thinking. It doesn't feel to me as though it's got long-term policy in mind. It's very much let's grab a headline and try and get some votes. That's what it smacks of to me. Again, along similar lines, I don't know if you sort of recall, but there was a lot of noise around fitness for habitation. And that came in, again, it's pre-COVID last year. But, that legislation, that actually, from a private landlord's perspective, almost no change. That simply codified requirements that were already there. And so it was just an act of parliament that kind of gave people an access to a headline in a newspaper that sounded as though property should be fit for habitation. And I'm kind of like, we're not in Dickensian Britain here. There are proper housing standards. Tenants pursue disrepair claims every day of the week. So I sort of, they already had these rights. You don't need to put that in an act. It's just noise. Where's the substance? But anyway, I digress.
No, I love it. I love it. I say similar things going back to that stamp duty, and I don't know whether some genius down in Whitehall has thought about it or didn't think about it. I'm going to guess it's the latter if I had to pick out of the two. And saying, again with stamp duty and, what's the effect that's going to have? Well, a lot of pent up demands out there and people are buying, because you really need that psychological confidence of the people in what's going on. The challenge I can foresee with that, Alex, is that you've got this situation where, the rest of the economy is not doing very well, let's be honest. and it will continue not to do very well for quite a while because we're dealing with virus and stuff like that, and et cetera, et cetera. But at the same time, you're stimulating the housing market. So the housing market is doing well in a time when it really shouldn't be doing that well, and that'll create an artificial bubble, which we know what happens to bubbles. So, but that's all. Again, just go back to the point that correlates with what you're saying. I don't know whether someone in Westminster has actually Whitehall has actually thought of that with that policy, because you'll look at it and go, oh, no stamp duty or whatever, and people go, fantastic, cheers government, and crack on it, and don't think of the longer term impact. Do you think that's fair, or am I just being a bit crazy?
No, look, I agree. I've seen the stamp duty stuff referred to as kind of stealing next year's market and kind of funneling it into this year, kind of bringing it forward. Anyone that might be thinking of doing something next year, thinking, oh, well, I may as well do it now. But again, what are we trying to achieve here? What's the aim in all of this? We're trying to encourage inward investment in housing, because I think we need to be. If that's not the policy, then, from my perspective, it should be. And that needs to filter right the way through, from social housing right the way through to sort of grease the wheels on the chain, as it were, in housing stock. And so it's kind of a supply and a demand type approach. But on the one hand, with stamp duty, you're incentivizing that inward investment, which I get, good. But on the other hand, by making evictions much more complex, time consuming, etc., you're actually just turning off completely those investors. That is not something that really, people want to know that if people don't sort of honour the deal that has been struck in terms of paying rent or whatever it might be, that ultimately they can regain their asset, and they need to know that they can do that in a reasonable period of time. And that is what is currently under threat, I think, in terms of what's going on, striking that balance. Because, for a lot of people, they may turn around and say, do you know what? I used to think of property as being something for a pension or, an alternative bricks and mortar, the value of bricks and mortar. But when people start to understand how long it might take now, I don't know if that's going to continue. And that's not good for our housing economy, for housing generally, including for tenants, as I've said. It reduces the amount of housing stock available, which will naturally increase rents. We're already seeing that. Rents have gone up. And so it's kind of, again, I just think it's not for me party political, in the sense of I'm not sure you can really pin this on anyone, in terms of political parties. I saw some scary stuff being proposed by Jeremy Corbyn and Labour, which has obviously fallen away with his demise, we assume. But, so I don't think it's party political in that sense. But I do think this is a political issue now. And, landlords probably need to get a little bit more organised and a little bit more vocal about the impacts that some of these decisions have in a much more organised, streamlined way than I've seen. The tenant organisations have much slicker marketing and PR sort of machinery behind them.
So it's not like our government to not have good PR. I'm just thinking of HS2. It's probably the one thing that strikes to mind. Anyway, again, different topics for different time. But I love what you're saying there, because I think that's so true. And I think the challenge that's always going to exist with what you've said is that politicians are, rightly or wrongly, whatever we want to believe, they're always going to look out for themselves and what's going to get the people to vote for me to give me my seat in Parliament, for next term.
It's that dopamine, it's that immediate dopamine hit that they're looking for, and it's kind of the impact. As I say, the Housing Act 1988, that's the legislation that is our kind of go-to. This is not like last year or the year before or the year before that. This is it's stood the test of time, at least in the short term ish and legal terms. But I think woe betide we dabble with this stuff to sort of a relaxed way, because the implications and the impact can be. The ripple, the waves are just extraordinary if we're not careful. But yeah.
Yeah, we must have that long-term approach. Well, Alex, I'm going to ask you to look into your crystal ball for a little bit. So obviously we touched on a variety of things, Section 21, Section 8, what they look like pre-March, what they're looking like now, this sort of pent-up demand that you're seeing. With everything that you're experiencing from your point of view, and again, it's a crystal ball job, I do appreciate that. What do you think's going to happen here? What do you think people are going to see moving forward?
I think again, let's just understand the context of the world that we're in. Because of the bottlenecks, in the next 6 to 12 months, we know that the courts are going to be very busy. Okay, they're already busy, and it's not just with landlord and tenant work. There's a lot more debt type claims floating around, and there are also, of course, the commercial property elements that, not something for today, but all of that is a live issue too in terms of retail and just commercial property having been impacted. So you've got vast swathes of disputes trying to get themselves into the court process, and that necessarily slows everything up. So there's an immediate impact there. But I think there's also policy changes that this is going to trigger, because local authorities can't deal with lots of claims being concluded at the same time. Okay, and the sort of the link between the courts and the local authority is on paper non-existent, but in reality, this is very real. It's the sort of thing that governs changes in court process by government precisely to soften the impact. Dare I say it, flatten the curve. But these are the sorts of changes that they will look at, and so I kind of expect, and we can already see some of this filtering through, that the court process for evicting will change, and it will take landlords longer, but there will also be additional hoops that need to be jumped through. We see this at the moment in the short term, pre-March or until March 21, where landlords have to deal with reactivation notices or provide additional information to the court on the impact of coronavirus on the tenant. And if they don't do those things, then their claim will not be progressed. So you can already see that there are just these additional steps that are kind of creeping into the court process. And I think there'll be a lot more of that. And that's in the short term. In terms of policy, I think there are, again, some bigger issues that are now coming to the forefront. And from my perspective, I might say slightly cynically, but I'm kind of frontline. We deal with a lot of these claims. I think you're going to see a lot more talk about things like mediation, okay, alternative dispute resolution, ways for landlords and tenants to be encouraged to resolve their disputes without them needing to go through the court process. So I think there'll be lots more of that. We've already seen this in the commercial courts that I deal with, particularly High Court, and actually, even in the county court, there's now a big push before any claim is issued for the parties to look at alternative ways to resolve the dispute. Landlord and tenant has always been kind of excluded from that because, actually for reasons that I can't really explain, but it's never really been something that's been a focus. I think the assumption is that tenants don't want to negotiate or that people have already tried. That is, by the way, my experience, as I've said already. But, again, I think this is all going to become more formally required to buy everyone time. So mediation, another big one, I think will be pushed heavily, and everyone will probably at some point be required to mediate. And the other thing that is kind of just still floating around is the idea of a housing court, to pull these disputes outside of the county court. And again, you've got to see this in the context where these claims, even pre-March, pre-coronavirus, you would have a busy possession claim list in a county court, and it might be that they've got 30, 40 claims on a Tuesday afternoon or, Tuesday, and they've got 5 minutes get allocated to each claim. That's what we're talking about. That was the reality in February, January. In any court in the country, you could find that. And now the volume is just going to be such that actually they were already talking about this. There was already this conversation going on, but pulling these out into its own specialist court. We've done this in Scotland. It's not been good for landlords. It's taking a lot longer to regain possession. But again, I can see why, from a policy perspective, to try and keep the courts moving, etc., that may well rear its head again. So I think they're the kind of big two things that I can see, certainly longer term or medium term, coming in, as well as in the short term, some additional hoops to be expected at any given moment to just be kind of lumped on us all.
I think that's a fascinating insight, to be perfectly honest with you. I think that's also a very good place to leave that for now. I think, I don't know how you would feel about it, maybe jump on another episode, maybe, I don't know, maybe 6 months to a year to, track the progress. If you'd be up for that, I think that'd be good.
Absolutely. Yeah, no, that'd be great, Rob. Yeah, thanks very much. Lots going on.
Now, finally, Alex, if people want to get hold of you, people got questions to ask or want to do some work with Helix, or how do people find you?
Sure, thanks, Rob. Well, look, I'm a partner. I own Helix Law. We act nationally for landlords and investors with disputes, so I only deal with problems. Best way by far and away to contact me is via email. My email address is AC, that's Alpha Charlie, at helix-law.co.uk. landlords.com. Thanks for asking.
That's great. And as usual, we'll put all of that in the show notes and also put the links to the articles, say for Bloomberg and bits and pieces like that. All of that will be in the show notes. But Alex, thank you very much for your time. Thanks for your insight as well. And yeah, I look forward to having a follow up in 2021.
Absolute pleasure. Thanks very much, Rob. Good luck to all.